Yes, call the judgment.
From the main list, pronouncement of judgment, item number 1.
With regard to claim number 1, the learned arbitrator has valued the work done at 45,69,663, valued the material at site at so-and-so, totaling to so-and-so. Hence, out of a total claim of 35,37,346, 22,74, etc. was allowed. The learned arbitrator, while partly allowing the claim, has tried to compute the value of the work and materials, taken into account the payments received by the contractor, and also disallowed some sub-claims with the reason not adequately justified. We find that the reasons given are succinct but very acceptable and most adequate. As far as claim number 2 was for infrastructure set up by the appellant, the learned arbitrator inter alia held that this claim was exaggerated. No sanction of GE was obtained to set up the infrastructure, and allowed 25% of the claim, amounting to 232,600. This part of the award, in our opinion, cannot be sustained. The arbitrator under section 28(2) of the Act of 1996, as applicable at that point of time, was to decide the dispute in accordance with the terms of the contract. When the contract was awarded to the appellant, it was expressly provided therein, or to be implied from the terms, that the appellant would have to set up its infrastructure to execute the contract. The value of the contract included the cost incurred in setting up the infrastructure. In claim number 1, which necessarily took into account the infrastructure expenses, the appellant claimed and has been partially awarded the balance claim for the work done. An award for the amount expended on account of infrastructure could not have been separately claimed or awarded. There was no justification for an award for this claim. So this is an error of law apparent on the face of the award, rendering that part of the award patently illegal. This part of the claim was rightly set aside by the learned judge. 3 and 4 were not awarded. Claim number 5 for 6 lakhs was an account of loss suffered for deployment of idle labor, TNP personnel, etc. Claim number 6 was for 60 lakhs, claimed similar damages on account of overhead charges, idle TNP personnel, labor and other establishment at head office and profit. For each of these claims, the learned arbitrator ruled that there was no evidence to justify the claims, but nevertheless he awarded rupees 2,50,000 for each of the heads of claim, stating it was lump sum to meet the ends of justice. Regrettably, this is no reason at all. The decision is flawed. When, according to the finding of the learned arbitrator, there was no evidence to justify the claims, he ought to have rejected them. He made a random award relying on his conception of a just award. Here he misdirected himself by failing to properly appreciate the consequences of lack of evidence. The reason given is against law and constitutes a patent error of law apparent on the face of the award. He had no jurisdiction to do charity. Hence, the award of rupees 5 lakhs against claim number 5 and 6 was rightly set aside by the learned judge. Claim numbers 7 and 8 relate to grant of interest and costs. We do not find any reason to interfere with those claims as they are in accordance with law. Now we have to deal with the argument that the award is vitiated by the arbitrators failing to consider the counterclaims. We have held that the claim for a counterclaim could not arise in view of the claims awarded. There was no scope of any counterclaim. The appellant approached the court under Section 11 of the said Act for reference of his claims to arbitration. The respondents do not appear to have made any counterclaim at that stage. Naturally, the order of court referring the matter to arbitration referred to 8 claims, which the arbitrator has decided in the body of the award. Thereupon, when he called the parties to a meeting, the respondents indicated that they had a counterclaim. Thereupon, he directed filing of a statement of claim and counterclaim, if any. We find nothing wrong with the learned arbitrator's reference to 8 claims initially. It is true that before pronouncing the award, the arbitrator remarked that he had considered only the 8 claims. There was no reference to the counterclaims. He has made a mistake making this statement. The award is more than 20 years old. If we have to set aside the award on this ground and direct the parties to seek arbitration afresh to consider the counterclaims, it would reach more injustice than justice. The matter has to be looked in this way. The learned arbitrator ruled that the respondents were in breach of the contract and that the appellant had rightly treated their conduct as abandonment of the contract. Thereafter, the appellant rescinded the contract. The learned arbitrator held that rescission by the appellant was rightful. No breach of contract was attributed to the appellant. This finding upheld by us expressly or impliedly suggests that the appellant could maintain a claim against the respondents, but the respondents could not maintain one for risk and purchase or otherwise. It negates even consideration of any counterclaim by the respondents. Therefore, only the claims of the respondents were admissible and payable. We are prepared to give latitude to the technical arbitrator when he made the statement that he only adjudged the 8 claims. Consideration of the counterclaims would have been an idle formality. So would it be now if we order referral of the counterclaim. The reasons given by the learned arbitrator to support part of the award which we have upheld are more than adequate and reasonable and accepted by us. Therefore, the learned arbitrator's observation and finding in relation to that part of the award which we have upheld, that it is vitiated for non-supply of reasons, is completely erroneous, liable to be set aside, and is set aside. This appeal is partly allowed. The award is partly set aside. The award for claims 2, 5, and 6 is set aside. The rest of the award is upheld and may be enforced. The impugned judgment and order is partly set aside. No order as to costs.
Item number 2.
Much obliged.
Advocate General, we have held against you in this matter. We have held that the lease agreement of 1st June 2022 is legal, valid and binding on the respondents. The decisions embodied in the notices dated 14 July 2023 and 16 January 2024 are declared invalid and set aside ab initio. The respondents are directed to restore the staff provided by them to the appellant's weighbridge within 2 weeks from communication of this order. The respondent should provide full assistance to the appellant to operate the weighbridge during the operation of the lease dated 1st June 2022. With regard to setting up of another weighbridge by the respondents 2 km away from the site of the present weighbridge at Amjeha, the appellant has liberty to take such action that may be available to him in accordance with law. We have not dealt with that. The impugned judgment and order dated 20th May 2024 is set aside. The appeal is allowed.
Item number 3.
Hence, the respondent was absolutely right in contending that his next promotion under the said scheme was due by 1st January 2010, which was effected only on 4th February 2015. Likewise, the promotion to grade E was due by 1st January 2014. He was promoted to grade E only on 2nd March 2020. There is no dispute that the respondent's gradings in the annual confidential reports were always outstanding and very good. Therefore, there was no reason to deny him promotion. In case of a scientist of the Botanical Survey of India, where the facts were quite similar, Union of India was S.K. Murthy, the Supreme Court, with a judgment and order dated 2nd May 2011, affirmed the order of the High Court directing the Ministry to promote the scientist from the date of acquiring the eligibility under the Flexible Complementing Scheme FCS. For the above reasons, we find no infirmity in the impugned judgment and order of the tribunal. We affirm the same and dismiss this writ petition. No order as to causes.
Item number 4 and 5.
I crave your lordship's indulgence, well, it's to make a mention before the main list is called out.
Sorry?
If I may crave your lordship's indulgence to make a mention for an urgent matter, my lords, for listing tomorrow. It's an appeal arising out of a judgment of the learned single judge, whereby, my lords, and direction has been given my lords, in addition to imposition of costs, some disciplinary proceedings have been directed against the respondents, my lords, who are members of a corporation. If my lords kindly have it tomorrow, my lords, we've already filed the appeal.
But give notice, sir, both puppies.
We'll serve notice, ma'am.
All right. This
Hello.
tomorrow.
Obliged.
Item number 4 and 5.
Lordship, if I can be indulged, my lord.
Yes.
If I can be indulged, my lord, a similar prayer. There is a pending appeal which was listed on 10th. Appeal against single judges. It was supposed to be listed before regular bench, this honorable bench. But we find, my lord, now it's been listed on 6th of March. There is some urgency because he responded.
It must have been adjourned by consent of parties.
It was not taken up due to unavailability of the regular bench, my lord. This was on the 10th, my lord, of this month.
It could not have been 16th March unless Chris was
6th
the order.
March. 6th March.
Who was the order?
This is, my lord, writ appeal 72. It's not listed today. It's now listed on, as per the CIS, my lord.
How it was posted on 6 March, we have to see.
72 of 2024. Writ appeal.
You find out, come at 1 o'clock before rising.
Right.
Item number 4 and 5.
May it please your Lordship. This is the matter that has come back on remand by the Honorable Supreme Court. The orders of the Honorable Supreme Court are here.
Hearing of the appeal.
My lords.
Yes, we were shown this order.
Yes,
My lords.
Lordship has been apprised of this
Yes,
order.
my brother has not seen it.
Yes.
Lord, the may it please yours.
Yes.
Lordship, Hospital Management Society, my Lord, Tura, invited bids for setting up of 1.5 Tesla MRI machine, my Lord, in Tura Civil Hospital.
Would that matter? We directed that
Interim order was passed that,
that you operate the machine.
yes, my Lord, during the pendency of appeal, that part of the order was taken by the respondent to the Honorable Supreme Court. To that extent, that interim order was stayed by the Honorable Supreme Court with request to this Honorable Court to hear the matter expeditiously. My Lord, very short issue is involved. I can
That means there is no machine which is operational there.
as on today, there is
Machine has not been applied.
My lords, I appear on behalf of the successful bidder, my lords, the appellant in item 5. My lords, after the interim order was passed by my lords court, we have in the meantime procured the machine. We have finished the civil work on the site. And in fact, my lords, the Faraday cage and several critical parts of the machine are today lying in the hospital. My lords, even the machine itself
That
had
was
come.
not submitted before the Supreme Court.
Lords, all of this was, my lord, and in view of the same, my lords, it has been
The facts of this
decided
case,
to
my lords,
be
this
decided.
plea was not entertained. I'll just take your lordships to 3 pages, my lord. I will explain the entire matter.
Let me please, my
Let them finish, my lords. I'll just take your lordship to 3 pages.
With my lord's permission, my lords, since the appeal in item 5 is moved by the successful bidder, before the state addresses submissions, may I make a few submissions, my lords?
Let me first
Very
make
well.
this myth.
You are the successful bidder.
I'm the successful bidder, my lord.
State
I'm
has
appellant in item
important
5.
role to play.
The learned advocate general has precedence over all.
Of course.
State has important role to play. Lord, kindly see page 24. Paper book, yes. Page 24 of the paper book, your lordship has paper book, my lord. Paper book is now.
Okay. Then when paper book is filed, this has become redundant now.
Now, your lordship, kindly see the page 24. This bid was invited on 3rd October 2023, my lord. Bid document for installation of 1.5 Tesla MRI machine at Tura Civil Hospital, Tura. The clause 1, my lord.
Yes.
The Hospital Management Society, Tura Civil Hospital, invites bid from eligible and qualified bidders for supply and installation of 1.5 Tesla MRI machine for Tura Civil Hospital. Your lordship may kindly mark this, that the bid has been invited by Hospital Management Society, because this will become relevant, my lord, for the purposes of deciding this appeal, my lord. One more clause, your lordship may kindly take note, is clause 12. at page 26 of the top.
Use some flags.
Page 26, clause 12, my lord. The Hospital Management Society, Pura Civil Hospital, is not bound to accept the lowest quoted rates and reserves the right to reject any tender or part thereof without assigning any region and without any liability or liquidated damage, my lord. The authority which was vested to accept the bid was, my lord, the Hospital Management Society, my lord. The learned single judge, my lord, why I am showing all these clauses, learned single judge has held that the Deputy Commissioner, who was the chairman of the Hospital Management Society, was not competent. It was the Tender Advisory Committee which was competent to decide who will get the bid. Controversy in this case is, my lord, that who is competent to decide who should get the bid, and on that basis, my lord, the letter of award has been set aside. The bid was invited by Hospital Management Society. Authority which was competent, my lord, was Hospital Management Society, my lord. And your lordship will find the clause relating to technical bids, my lord. 15, my lord. The decision of the committee on technical suitability and quality shall be open for discussion. Every bidder must go through the terms and conditions of bid carefully and understand them before submitting the bid. No excuse that the conditions have not been read or understood will be entertained. So, clause 15 refers to the technical aspects, my lord, that it will be open for discussion. That is the clause, my lord. And 27, my lord, is also important clause of the tender, which has been taken into account, my lord. 27 at page 27. Installation, demonstration, operational techniques and associated services, if any, to be provided by bidder free of cost. So there were certain services also embedded in providing the machine, my lord. This was the one of the requirement. This bid, this tender document, my lord, usually had this techno-commercial bid and commercial bid component, my lord. These are the only provisions which, to my understanding, according to me, my lord, is relevant, my lord. Now, the next, then two of the petitioner and sorry, my lord, the private respondent number 5 and respondent before your lordship became successful bidder, my lord, and their bid, my lord, will find that at page 160, my lord,
Both qualified in the technical round.
both qualified in the technical bid, my lord.
Respondent number?
Respondent number 5 and in my appeal they are respondent number 5, my lord, and respondent number 1, my lord.
And Mr. Paul's?
Petitioner, respond number 1. my lord.
Respondent number 1, my lord.
In the state's appeal, I am respond number 1.
You also qualified in the
Yes, yes, both technically qualified, my lord. And there your lordship will see that page 160, both are technically qualified, my lord. The page 60 of the paper book, my lord.
Six zero.
160, my lord. I'm sorry. Page 160, my lord. And third line at page 160, my lord. This 8th November 2023, 8th November 2023, my lord, tender was opened in presence of tender advisory members and the presence of supplier parties, my lord. The respondent number 1 submitted the bid and the price of the bid was below 11 crore 95 lakh. And respondent number 5 bid was below 10 crore 33 lakh 75,000 rupees, less than about 1 crore, lesser amount than the respondent number 1. Now, your lordship, kindly see the bottom part. The tender after the table, my lord, the amount is quoted. One is 1.5 Tesla MRI machine, my lord, and both amount is quoted. One is of Siemens and one of United Imaging. The tender committee and technical expert committee, after examining the tender bid and specification of both parties, noted the following advantage in Siemens Megatron XA50 MRI to be supplied by MAG India suppliers. Siemens has latest models. Total imaging matrix is so and so. These advantages were read out, my lord. And your lordship, on next page, your lordship, the next page at 161. Is the signature of the additional deputy commissioner cum chairman MRI Tura Hospital. He was member of joint Director Health, cum Superintendent Tura Hospital, and some of the expert members are there, my lord. Their discussion, my lord, is from page 162 onwards. There is a discussion at page 164, my lord, of the minutes. 164 of the minutes, my lord. Fourth paragraph. Fifth paragraph, my lord. The radiologist Amitabh Datta, Dr. Preetham Sangwan, senior radiologist Dr. Mami Armara gave their opinion requirement regarding the machine put up by the two parties.
Page 160?
4, my lord. 164 and fifth paragraph, my lord. Radiologist Dr. Amitabh Datta, Preetham Sangwan, senior radiologist Dr. Mami Armara gave their opinion requirement regarding the machines put up by two parties. Dr. Amitabh Datta, radiologist William Nagar, Seal Hospital, gave his views that Siemens is a reputed brand with good service throughout the country. Northeast by India, he also mentioned the model number so-and-so machine by Siemens was fitted with most recently updated magnet, hence was latest version, good patient compliance in relation to breath holding during MRI. Dr. Preetham Sangma, radiologist, mentioned that although experience with both companies put forward by the competing tender is limited, however, he was of the opinion that Siemens is a renowned brand. Dr. Mami Armarak, senior radiologist, Tura Civil Hospital, he is the hospital, said Megatron Sempra 1.5 T MRI machine by Siemens had the reputation of being technician friendly and had more number of channels, therefore reducing artifacts, and also software use is user friendly. She also mentioned that, however, that poor service response for single slice CT scan machine installed in Tura Hospital by Siemens had to be noted as past experience of the hospital. So the different experts gave different opinion, Miller, and thereafter, Miller, further examination was carried out at page 166, my lord. Page 166, notice was given to both the parties to make further presentation before the management society, my lord. Page 166, the notices were issued, my lord. to both the parties to make their presentations. They came and made the presentation, which your lordship will notice at page 167. It's a minutes of the meeting chaired by chairman of the Tura Civil Hospital, which invited the bids Miller, Jagdish Chelani Miller. The pros and cons were examined by the technical members, expert members Miller, and your lordship will find the conclusion of, in fact, your lordship kindly see the threadbare analysis and discussion of the various aspects of the matter, because the learned single judge has held Miller that there was some deficiency in this minutes Miller, and if your lordship will see that the technical members were part of it and detailed examination, elaborate examination has been carried out. For that purpose, Miller, I will just show 1 or 2 pages and then thereafter finding of the learned single judge Miller. Kindly see page 167 bottom. Official of Arring Medical Supplier, United Imaging L1 presented the salient features of their MRI machine and they claimed that their machine is the best and all latest qualities are shown below. United Imaging Healthcare has global presence, having bid R&D in China, Shanghai, Houston, USA. Companies manufacture and many innovation in radiology, imaging, radiotherapy like world so and so Miller. 2, in India they have 75 plus installation of MR 580 model, including 3 in northeastern India, private hospitals, etc. Miller. Company officials, they gave the elaborate presentations. Similarly, my lord, Siemens also gave the elaborate presentations. On next page, your lordship will 168 bottom. At the MAG India's presentation is at 169. The company has its base in Germany, has business roots all over it. Then, my lord, at the foot of the page, my lord, the conclusion of the committee is there at 169. The officials of MAG India concluded the Deputy Commissioner Chairman, Tura Civil Hospital, Tura informed in the presentation and points of both the company officials have been noted and observed carefully by members of the committee, my lord. The undersigned in consultation with the tender committee compared the facilities claimed by official of both the companies. The below mentioned point has been observed. Arring Medical Supplier, that is L1, is a claim to provide a machine which is lower in cost and offering facilities higher and better than machine offered by MAG India. L2. However, L2 claims to provide better service support architecture. Undersigned applies L1 Arring of assured and better services provision provided by L2 MAG India supplier and achieved the assurance ability of L1 to match the same during the warranty period. Next, the undersigned, as the chairman of the committee, concluded with the better technology and a machine service provision at significantly lower cost warrants the selection of L1 as preferred bidder for procurement. My lord, and kindly see the committee, my lord, consisted of technical members, the experts and representative, my lord. One member from the previous committee, my lord, I have shown, my lord, that one member from previous committee, my lord, at page 160, Mr. Datta, Amitabh Datta, who was a radiologist in William Nagar, who was junior to Mami Armanak, senior radiologist, Tura Civil Hospital. He was not present on that meeting, my lord. Now, and then your lordship will see the comparison table at page 181 of both the companies. This kind of analysis was not done earlier, my lord. Every bit of analysis has been done of both the machines, my lord, starting from 173 till 181, and then your lordship will find the tabular charts are there. The experts went into all these details. Thereafter, they decided that L1 is having all the qualities, everything. The learned single judge, my lord, held that, and one more aspect, my lord, the petitioner will file the writ petition, my lord. He suppressed the fact that he has participated in the assessment process held on 21st December, my lord. he suppressed this fact, concealed this fact.
L1 is Magenta.
Yes, L1 is Mag India.
L1 is
Aring, sorry. L1 is Aring.
L1 is Aring.
Aring. That you will also find at page 160. Mag India is having 11 crore 95 lakh. And Aring is having 10 crore 33 lakh 75,000.
So the committee had selected Aaron.
Aring, because and committee also examined the technical aspects and found that Aring is meeting all the requirements. What learned single judge held, my lord, that Deputy Commissioner was not the competent authority to examine all these matters. Only Tender Advisory Committee is the final authority to award the tender. And examination by committee headed by the Deputy Commissioner is outside the terms of the tender, my lord. That is the finding which has been recorded by learned single judge. If your lordship will kindly see the finding at page. My submissions have been noted at page 408, my lord.
But in the minutes, we find that the deliberation was that Siemens was superior.
No, in minutes, my lord, the deliberations are that the lowest bidder is fine. Your lordship will find that your lordship will find at page 166. Let me finish.
There are two meetings, Millets. That is what is creating the confusion. The first meeting is, Millets, what your lordships have referred to, that the expert committee says that Siemens is a better machine.
This is also by expert committee also.
I'll clarify on that. Subsequently, there is another meeting, Millets, where it is given to Aring and Aring is declared as L1.
Yeah, and in first meeting also, your lordship has noticed at page 163 that there were issues with the service of Siemens, which was highlighted by senior radiologist of Tura, my lord. Kindly see page 169 where finding is there of the expert committee headed by the chairman.
169.
And both are technically qualified, my lord. Both have been technically qualified. After technical qualification, my lord, your lordship will find that in third paragraph.
Page 169.
169, my lord. Third paragraph from the bottom, my lord. Finding the undersigned in consultation with other members of tender committee compared the facilities claimed by officials of both the companies and below mentioned points have been observed. Arranged medical supplier, United Imaging, L1 is claimed to provide a machine which is lower in cost, offering facilities higher and better than machine offered by the Mag India. So-and-so, my lord. L2 claims to provide better service support architecture. Undersigned applies L1, Arranged medical supplier of assured and better services provided by L2, Mag India, and received an assurance, my lord. Now next, 170. Undersigned as the chairman of committee concluded with better technology and matching service provided provision at significantly lower cost warrant the selection of L1 as the preferred bidder for the procurement, my lord. And this exercise was carried out, my lord, extensively. If your lordship will see the comparison table of both the services and technical aspects, my lord. First was the advisory committee. Advisory committee has got different opinions, my lord. In one of the opinion which was highlighted, then again the management committee met. Management committee went into extensive detail. Both the parties were asked to give their presentations, and it found that L1 is having better technological inputs, better technological capacity, and it decided to award the contract, my lord. Now, learned single judge, my lord. On very limited ground, my lord, that
No, where is the final decision to award the contract?
that is at page, my lord, 153. Sorry, but that is where is that decision? Give me the page. 244, my lord.
244.
That is dated 9th March 2024, my lord. Work order for supply and installation of 1.5 Tesla MRI machine. Seal work MRI from so and so with reference to this was the order placed, my lord. In the writ, my lord, in the writ petition, the prayer of the writ petitioner, my lord, at page 19, my lord. One nine.
So here, the final decision is to be taken by the Deputy Commissioner.
By the chairman of the management society, my lord.
That is the rule.
Because your lordship will find in the heading of the note itself, my lord.
Clause 12.
Yes, my lord. The bids were invited by Tura
Hospital Management Society.
Society. Tender advisory committee was advising the society, my lord. Minutes with
And the Deputy Commissioner is the
the chairman of the hospital management society, my lord. And he took the decision in consultation with all technical members, my lord. It's not his own independent decision. The decision was taken in consultation with all members. If lordship will see the proceedings at page
162.
167, my lord. Top. Sit down. top, my lord. Sri Jagdish Chelani, IS Deputy Commissioner, West Garo Hills, the chairman of Tura Civil Hospital. And at the beginning itself, my lord, at page 22, I have shown 24 that the bid was also invited by society only. In any bidding process, my lord, the tender advisory committee will not become the authority to decide who will get the bid. And at 170, where the chairman is taking a decision, my lord, at page 167, at page 170. Page 170. The undersigned as the chairman of the committee concluded with the better technology and matching services provision at significantly lower cost warrants the selection of L1 as the preferred bidder for this procurement. So this decision was taken by him as chairman of the Tura Civil Hospital. And Hospital Management Society invited the bid, my lord. I have to show only 2 pages of the writ petition, my lord. Kindly see page 22, page 19 of the prayer, my lord. Page 19 of the prayer of the writ petition, my lord.
Which page of the paper book?
19. Withdraw the award of 3/10/2023, my lord. and the prayer is quas the award dated 3/10/2023. There is no prayer or direction whatsoever sought. There is no prayer that the tender should be awarded to the L1, my lord. So therefore, my lord, as a state, my lord, if it is quashed, again I have to go back to the same process. I have to issue the fresh tender and I have to invite the bids, my lord. Because L1 automatically will not, the only remaining bidder will not, single bidder may not get the bid automatically, my lord. That is also a settled law, my lord. Second, my lord, his case, the petitioner's case was based on one letter, my lord. That is at page 153. Sorry, 151 of the letter written by the government to the
Society has how many members?
Society has, my lord, that details are not there, my lord, on record. It is not even pleaded, my lord.
It is there, my lords. I'll point out.
How many members are there?
Well, altogether there are 8 members.
All doctors.
One is the chairman, my lords, and the rest are the doctors. That is why, my lords, that one very crucial aspect of the matter which has been left out by the learned advocate general is there was a specific direction by the government of Meghalaya that there should be an independent member heading the tender committee.
I'm placing page 151, my lord.
That aspect has been completely.
I'm coming. 151.
After the NIT, my lords, would kindly read this letter at page 151, my lords.
I'm reading that letter. Reading.
This is left out earlier.
I'm just going to your first my case, then your case, then we'll find it. Now, my lord, what my friend is saying, my lord, 12th October letter, my lord. With reference to this item, I am likely to invite the reference of letter to say that Superintendent Tura Hospital may constitute purchase committee through executive committee of EC of Tura CL Hospital for procurement of MRI machine for hospital with designated function overseeing the procurement of material equipment. Mandatory to the committee include at least one member with technical expertise in the field. The procurement committee is to ensure professionalism, economy, efficiency, and integrity in procurement. This includes local purchase method, etc., related to so and so, my lord. Now, what my friend is saying that this should include one expert member, my lord. And if your lordship kindly, my friend's emphasis that it should include one expert member, and kindly see 167, page 167, my lord. It included more than one expert member, my lord, and what my friend is saying that only expert member as per him is Mr. Amitabh Datta, my lord. Kindly compare page 160, my lord, with 171.
Same people besides Amitabh Datta.
He is saying that since Mr. Datta was not there, the recommendation of page 164, you also will find the name of 3 radiologists there. 164, 1, 2, 3, 4, 5th paragraph. The radiologist, Dr. Amitabh Datta, Dr. Pritam D. Sangma, and senior radiologist, Dr. Mami R. Marak. Amitabh Datta, will also find his designation on next paragraph. Dr. Amitabh Datta, radiologist, William Nagar. Then second is Dr. Pritam D. Sangma, radiologist, Tura Civil Hospital. And third is senior, Ms. Dr. Mami R. Marak, senior radiologist, In the meeting held by the committee, Mami R. Marak and Pritam D. Sangma, both were present, Both were expert, both were present, And one member was not present, And that is what my friend is saying, that expert was missing, whereas we have got senior radiologist on record, and Pritam D. Sangma is also radiologist, and Amitabh Datta is a radiologist in William Nagar, not in Civil Hospital, Tura also, my lord. Kindly see now in the light of that, because learned single judge has not gone on that aspect of the matter, my lord. Learned single judge has gone that DC was not competent only tender committee was competent, my lord. That is the only reason on the basis of which tender has been set aside. Award has been set aside, my lord.
What is your suggestion, Mr. Advocate?
My submission is, my lord, that the bid was invited by Hospital Management Committee. In any process, my lord, in any tendering process, we constitute various subcommittees, my lord. There is a deliberations, discussions, and final decision is reached by the employer. In this case, employer was the society. Society has given it to L1. Society has evaluated the bids and found that the L1 was competent, which included the technical members. In my humble submission, there is no scope of judicial review when the process is followed, L1 is awarded. Now, both are technically qualified, my lord. I take it, for example, that the different members are having different views about the technical capabilities of the machine. But ultimately, if the decision is taken by the committee which says that the L1 is given, my lord, in my humble submission, there is no irregularity, there is no illegality, and that kind of latitude is always there with the administrative authorities, my lord. It's not that R5 was not competent, R1 is not competent, my lord, and I am getting the machine which is cheaper by 1 crore 10 lakh rupees, my lord. Why should I spend 1 crore? 1
crore 60 lakhs, my lord. 1 crore 60 lakhs.
Yeah, your lordship will see page 160. Why should I pay higher sum? And one of the radiologists is also raising the issue of service by the R5, my lord. What is wrong in my humble submission in the decision taken by the authorities in awarding to L1, my lord? Your lordship, see the 11 crore 95 lakh is the figure by the R5, my lord, Meg India, and the lowest is 10 crore 33 lakh 75,000, page 160. I'm getting a machine which is cheaper than 1 crore 62 lakh.
60 lakhs change.
You see, tentatively,
Yes,
these
sir.
things are occurring in my mind.
Yes, sir.
My brother will also express his views.
Yes.
The contract is awardable by the society.
Correct.
There appears to have been 2 meetings
Yes, my lord.
where there was divergence of opinion.
Yes. In first meeting, there was
specialists.
first meeting. Second, there is no divergence of opinion.
Radiologist. The first
Yes.
meeting there was.
Yes.
Then there was a second meeting.
Yes, my lord.
And the decision appears to have been taken.
Yes, my lord.
How these views were considered is not mentioned.
Yes, it is mentioned, my lord.
No, but the technical part is not mentioned.
It is their part annexed with this, my lord.
Yes, and it is said that because the
No, my lord, there is a
offer is lower, please come to the.
Yes.
Yes, my lord. I will just page 169, my lord. If your lordship will see page 169. And after that, my lord, kindly see I just, your lordship, take your lordship to the technical discussion part, my lord, which the committee carried out at page 173, my lord. Yes. This is also parts of that minutes of the meeting only, my lord. 173 onwards, your lordship will see competitive bids were invited for supply and installation of so-and-so. The system should be cost-effective with user-friendly platform, reliable and capable of providing excellent performance for clinical imaging, research.
Which page you are reading?
I'm 173, my lord. I'm sorry, my lord. 173. This is part of the
No, I was looking at page 169.
169 is the conclusion, my lord, and these are the minutes which are included with the minutes only, my lord. 173. Technical discussion is, summary of the conclusion is here, my lord, and detailed discussion is from 173 onwards, my lord.
Of this meeting.
Of this meeting, my lord. And there is no similar discussion or analysis in the first meeting, my lord. First requirements have been laid down at page 173 in thread manner, my lord. Each and every requirement. And then, my lord, in the said meeting only, if your lordship will see, the comparative table was prepared, my lord, at page 181.
No, 169, therefore the detailed minutes are?
169 is, my lord,
169 is the minutes, my lord.
minutes, and along with the minutes, these are the proceedings which have taken place in the minutes, my lord.
Page?
One, it starts, my lord, it's a continuation of page 1, minutes only, my lord. It starts from 167 and it ends at page 238, my lord. 167 to 238 is, my lord, entire deliberations, discussions, comparative chart, if everything is there, my lord. I'm sorry, I should have placed this also, my lord, along with my submission.
Of the second meeting?
Of the second meeting. 173, my lord, is the, each and every specification is listed out, my lord. And after listing out those specifications, my lord, at page 181, your lordship kindly see the comparative table. They went into each and every, including photographs, everything, my lord. It's not that, my lord, and your lordship kindly, in the first meeting itself, my lord, at page 160, they said that there will be meticulous examination.
164.
Page 164, my lord, in the first meeting itself, this has been spelled out, my lord. Para 3, my lord. Because first meeting there is no conclusive decision. Page 164, my lord, I'm sorry,
It's incorrect.
I'm just showing the
That is
paragraph.
incorrect from records.
I'm showing from the records only. I'm not showing from.
165.
Well, I will come to that also. My friend is relying on me lot. I will show that also. Good.
It is not inconclusive.
Paragraph 164, page 164, your lordship may kindly see.
No, the first meeting is 9 November 2023 at
Yes.
3 p.m.
Yes, my lord. 9th November 2023, my lord, and kindly see what my friend is relying on the decision or the conclusion reached by in the first meeting. But in first meeting itself, your lordship will kindly see page 164, paragraph 3, my lord. Paragraph 3, my lord. The superintendent informed the parties that committee would have to study the submitted document to reach a final decision, my lord. Committee is saying that it will study and examine and then it will
What
reach.
was the date of the second meeting?
And second meeting's date is, my lord, 21st November. Sorry?
21st December.
21st December. This date is there, my lord, at 167, my lord.
21st December 2020.
21st December, my lord. 21st December. These are the two minutes, my lord. Two discussion point, my lord. And in the first meeting itself, my lord, kindly see what was the minutes of the meeting. And my friend is relying on minutes of the meeting only to say that decision has been taken, my lord. Page 164.
These doctors were there at the second meeting.
Second meeting, my lord, except Dr. Amitabh Datta, everybody else was there, my lord.
The query that
And-
has fallen from my lords is that
and your
the
lordship-
doctors in the committee, my lords, the Tura Civil Hospital Management Society, these people who are posted in Tura Civil Hospital, my lords, they are automatically members. So there's only one independent person, that's
I'm
Amitabh
asking is
Datta.
this, Dr. Pritam D. Sagba was present.
Yes, my lord.
Pritam D. Sangma,
The
yes.
senior radiologist, Dr. Mani R. Marak was there, my lord.
And Lee Roser Marak.
Yes, my lord.
Yes, my lord.
There, my lords.
Yes.
At the second meeting.
Second meeting. Yes. And that I will prove from their signature and presence also, my lord. It is there in the minutes of the meeting. Your lordship will see that, just see page 164 top, my lord, third paragraph. The superintendent informed the parties that committee would have to study the submitted document to reach a final decision, and also right to make decision as per need of the hospital rest on the committee. Therefore, final decision would be made only after meticulous study, my lord. And on the next page at 165, my lord, which
In 10 or 11 days, they all change their mind.
I know, my lord, 165 only.
Nobody changed their mind.
On 165, my lord, 165. They say that after examining, my lord, so the committee, my lord, is yet to examine, and who is saying, my lord, will joint director, Superintendent Tura Hospital, my lord. And this kind of detailed exercise, my lord, kindly see at page 181.
Now, after the learned single judge's order, what will be the consequence?
The consequence, if the order is sustained, I have to go for retender, my lord. Process will get delayed. Machine will become more costly. Which machine will become more.
They called for a fresh tender,
Which was
then, my lords, then they came before your lordships, filed an appeal saying that we are withdrawing the order of fresh tender. They objected. Pursue an appeal.
Because, my lords, I objected, my lords, I have already been awarded, my lords, the second consequence will be that, my lords,
I'll speak with him separately.
This matter will take some time.
It will, my lords.
We will again hear it after the vacation.
Yes, my lord.
But to put an end to this,
Yes, my lord.
expeditiously disposing of the matter.
Yes, my lord.
Now it appears from both the meetings, subject to what my brother also finds,
Yes, my lord.
that both the machines are more or less technically the same.
Yes, my lord.
All right.
Yes, my lord.
At one meeting, they say that Siemens is superior,
Superior,
and
yes,
in
ma'am.
the other meeting, they says that the other one also may be taken.
Yes, ma'am.
It is technically all right.
Yes, my lord.
my lords, they say that mine is better, my lord. They say that providing better and higher facilities, my lords. My lords, the minutes itself says, my lords, the minutes, my lords, my friend will not substitute his wisdom for the tender committee. They say that the facilities are higher and better.
Well, if you have a word,
my
me for 5 minutes, I'll just clarify on three issues.
It is really unfair, my lords, because what the minutes themselves say is that the facilities are higher and the cost is lower by 1.6 crores, my lords.
Of a Chinese
Not merely that I am acceptable, my lords, it's that I am better and more price competitive.
Two options are available,
Yes, ma'am.
and we are very tentative about it.
Yes,
We can- Number one, that here the deputy commissioner has expressed his opinion. It
Yes,
seems.
my lord. Yes, my lord.
The majority opinion has to be expressed.
Yes, my lord.
1, 2, 3, 4, 5, 6,
Yes, my lord.
7, 8, all society members.
Yes, my lord.
And you go by the majority.
Yes, my lord. That this is by measure. If your lordship will see
It's not by the majority, my lords. Your lordships have nicely read it at 169.
your lordship will.
Undersigned as chairman.
And secondly, Mr. Advocate General,
Yes, my lord.
the second option is available, that you take both of them as technically more or less the same,
Correct, my lord.
have a kind of re-auction amongst the two. Whoever gives the higher, you take it, lower.
Lower. I have no issue. I'm happy. I'm more than, because I have to choose one.
This is just a tentative prima facie view. We will hear all the parties after the vacation.
No, I have no issue, my lord. This what has fallen from your lordship will serve the interest of the people, because I am only interested in one MRI machine, my lord. I'm lowest MRI machine.
I'm not going into the technological finesse
Yes, my lord.
of imaging
Yes, my lord.
gadgets.
Yes,
That
my
cannot
lord.
be, my lords.
Yes.
Only one single
I only make two submissions, my lords. Now, the difficulty would be that in the meantime, my lords, I'm out of pocket by 10 crores, my lords. I procured the
What can be
machine.
done?
I've got the machine, my lords. I'm given 10-15 days, my lords, the machine will be running. And it's a critical life-saving diagnostic tool, my lords.
What can be done? The Supreme Court has not given you that liberty. What
The same prayer was made
But
by
the final
them.
argument is not to be,
Second
that
occasion,
same prayer was made, and which is why the Supreme Court has said that let the court decide finally.
Naturally, my lords, your lordships would decide the appeal.
And the Supreme Court felt it would have closed you with an interim order and sent you here. That you operate subject to the result.
No, my lords, the direction is by consent, my lords. Both parties consented before the Supreme Court.
Facts, if I'm just pronouncing to your
Both parties consented before the Supreme Court.
We have to finally hear out the appeal. There is no scope of passing stopgap interim orders.
Yes, my lord. Yes, my lord.
Well, it's just two things, if I may just point out. On 9th, my lords, what fell from your lordships? The doctors say Siemens machine. On 12th, my lords, the R5 writes a letter to the Deputy Commissioner, which Advocate General did not point out before your lordships.
I will point it out, my lords.
He says, I am L1, so I should get the tender. Thereafter, my lords, there's a very interesting letter which is issued by the superintendent. He says, as directed by the deputy commissioner,
Meeting has to be.
all tender committee members are called.
My lords, my friend is not arguing piecemeal, my lords. My lords, as the appellant, I have to be heard before him. My lords, this is most unfair. He's presenting my documents before me in my appeal, my lords. That is most unfair.
We will hear all of you.
Then, my lords, people who have been lying 10 days
What is the is that the interest of one private party who's wounded, who's rejected, we put over the interest of the public, my lords. The expert committee has found me suitable, it has awarded me, I have performed at 90%, my lords. Now my friend, as a private party, wants the state, wants the right jurisdiction
does not
to be used to redress his grievance, my lords. He has submitted to the jurisdiction of the Tura Civil Court. If he has damages, if he has any claim, he can go there. But my lord, will the writ jurisdiction be misexercised to grant the private relief over the public interest, my lords? And my lords are please decisions on this effect, my
Public
lords.
interest. Public interest in such a kind of thing doesn't say you go for
As a matter of
the
fact-
you go for the lower product.
No, it's
It
the
says lower as well as the best.
Lord, as well as the best, my lord, this is exactly what is held in my favor, my lord. Lord, I will only read this out, my lord.
You don't buy an MRI machine
They provide a machine which is lower in cost and offering facilities higher and better than machines offered by Mig India
I
Medical.
have observed that your technical capability of your machine is comparable to them. There is no issue. According to the
It's better, my lords.
first and second meeting, the summation of
Yes, it's better, my lords. That's it. That's
thing
it.
has to
only difference is, my lords,
The only
one is a Chinese machine,
What
and
has
one
happened from your lordship is that if they agree and they take instruction and they come back to your lordship tomorrow by saying that they are ready for competitive bidding, I will get the machine, my lord. Inter-se parties, I will get a lower rate also, my lord. If they agree,
eight, my lords,
I need machine, my
that
lord.
reality of Meghalaya is, my lord, and I don't think my learned friend, the Advocate General, will, my lords, say anything.
that reality is the petitioners are coming
I
to court suppressing heaps of documents.
installed in certain hospitals, including in the headquarters in Shillong, my lords, and they are the ones
How will
machine
it is the argument of prejudice?
My lords,
when was the impugned judgment passed?
It was passed, my lord,
20th of May, my lord. 20th of May.
Hey, I'm sorry, my lord.
20th of May, my lord. Since then,
Just wait for a month. We will hear it out on the
Lordship
27th.
will finally hear us,
27th itself. 27th or 28th? January.
27 Jan.
lordship may have it on 20,
Oh, no, this is December, both are December.
not 20,
Just
4th December, sorry.
29 Wednesday?
29.
29th is a Wednesday.
29th is events.
All right. Advocate General appearing for the appellant in such and such appeal commences his argument but does not conclude the same. List these appeals for further hearing immediately after immediately on reopening of the court after the dispersed vacation on 29th January 2025 as the first two matters in the list.
Grateful, my lord. Grateful.
Obliged.
Item number 6.
Your Lordship,
Yes.
the conducting counsel is out of station. If this matter can bring up, out of.
Loudly, please.
Your Lordship, the conducting counsel is out of station right now. If this case can come up after vacation.
It is a commissioner's appeal,
Well,
35H.
well, 35G. They come after vacation, man.
Huh?
After vacation.
All right, on the prayer of learned counsel for the respondent, this appeal is adjourned till 12th February
Much obliged.
2025. Full stop. This adjournment will not be used by the respondent to take any steps in terms of the impugned order.
Item number 7.
Yes, please.
May it please, Lordship. Lordship, I pray that this matter may be taken up for revocation, my lord, since the senior conducting counsel is indisposed.
By consent.
Well,
All right, by consent of learned counsel for the parties. This appeal is adjourned till fifth February.
I'll have right.
Item number 8.
My lords,
Yes.
This matter pertains to the expansion of the Omroi Airport. Today it is fixed for the status report, whether to the approval of DGCA.
Yes, Mr. Advocate General and Mr.
My
Muzika.
lord, I am appealing for Airports Authority.
Yes.
My lord, the proposal has been submitted with the Directorate General of Civil Aviation, my lord. Because for lengthening of the runway, my lord, the landing procedure has to and safety aspect has to be examined by the DGCA. That has been submitted. That is
By whom?
by Airports Authority. It has been submitted to the Directorate General of Civil Aviation.
He is your head.
No, my lord.
Independent Technical Statutory Authority.
It is a statutory authority.
What is the difference in function? Director General of Civil Aviation and
No,
Airports Authority?
But Airports Authority only constructs and manages the airports, my lord. Now the safety aspect of landing and other safety aspects, my lord, those are regulated by
Maybe they are two departments of the same ministry.
No, but that's an independent regulatory authority, Director General of Civil Aviation.
separate statutory under 1937 Act, my lord, 1937 Act. So they see the whether the airport is safety is meeting the safety requirements or not. So they will have to do the technical.
The Shillong Airport Authority, or the Airports Authority, Shillong,
Right.
has submitted a plan.
To the DGCA, my lord. Now DGCA raised certain queries. We have answered those queries, my lord. So now it is we are expecting if the matter comes up after vacation, my lord, possibly we will get the approval or something from their DGCA by then, my lord.
In the meantime, we are also because they have given us some draft ideas.
You are appearing for?
State, my lord. State has been also asked, as per the last order, my lord, we have to update your lordship or apprise your lordship of the latest development, my lord. We are also taking steps to acquire the land because there is a proposal to expand the Bay Area, etc., my lord. So we are also carrying out this survey. So your lordship may have it immediately after vacation, winter vacation, and then we will.
The acquisition of land is a condition precedent.
Yes, my lord, because we have to have.
Height it is called OLS survey, my lord. Under the directions of this honorable court, OLS survey was carried out. That costed around 4 crore rupees, my lord. And by a specialized agency, the survey was carried out. Now they have proposed that about 6 to 7 acres of additional land will be required.
22 acres, my lord.
22 acres. So, well, if the matter comes after vacation, possibly we will get the clearance from DGC in the meantime, and the land acquisition also.
Extension of land is very important for the state. From time
Everything came deputation.
the state should acquire within a particular time and you should take it. Yes, okay. Has DG been noticed? Director General?
They are not a party, my lord. But they are a regulatory authority, my lord. and they are in touch with DCC.
Airports Authority.
Airport. We are pursuing the matter with DCC.
My lord, may I submit something?
Only because they raised certain queries after we submitted a proposal, my lord.
In order to expedite the process, my lord, I think the TGCA, my lord, should be noticed, my lord. Should be put to notice.
You please hear our order.
Yes, my lord.
This public interest litigation concerns development and expansion of the Shillong Airport. Comma. To be more specific, the issue involved is extension of the runway and development of infrastructure and other facilities. In and around the airport. Paragraph. In our view, this development of the Shillong Airport is key to advancement of this state in all respects. Full stop. It would facilitate the operation of larger, heavier, and more sophisticated jet aeroplanes. Comma, carrying both passengers and cargo. Full stop. This would further the economic and tourist development of the state. Paragraph. Learned Advocate General submits that measures have been taken for acquisition of land, which is essential for this development work. But that till date, the land could not be handed over to the Airports Authority. Paragraph. Dr. Muzika, learned Deputy Solicitor General appearing for the Airports Authority, submitted that the Director General of Civil Aviation was considering the proposal and plan for extension of this airport. Paragraph. Mr. Yobin, learned counsel for the writ petitioner, submitted that the development and expansion of the airport should be speedily completed, and that the Director General of Civil Aviation should be noticed. Paragraph. To this, Dr. Muzika submitted that the Directorate of Civil Aviation was working in collaboration with the Airports Authority of India, and that a separate notice was not required. Paragraph. We are of the view that it is high time that a decision is taken with regard to extension of the runway, development of infrastructural and other facilities, and overall expansion of the Shillong Airport. Next, we direct the state government to take all steps so that the requisite area of land is acquired and handed over to the Airports Authority of India, preferably within 3 months from date. Next, we also direct the Director General of Civil Aviation, in conjunction with the Airports Authority of India, to approve and implement a concrete plan for expansion of this airport within within 3 months of acquisition and handing over of land to the Airports Authority of India by the state government. Paragraph. List this application once again on April 14th to consider the action taken to consider action taken by the respondent.
My lord.
Full stop. It is desirable that such action taken should be in the form of a report to be submitted by the Airports Authority of India and the state government.
Obliged.
Yes. Which matter you were calling? Item number?
Item 9, sir.
Yes, for item number 9.
Item number 9.
My lord, we have received the copy of the affidavit, my lord, that is filed by the state, my lord.
My lord, as per Lordship's direction dated 14 October, my lord, we were directed to file a report in the form of an affidavit. We have already filed that affidavit, my lord.
My lord, we have received the copy, my lord. We are yet to go through, my lord. Let this matter come up after vacation, my lord.
Where is the report?
My lord, we have already filed on the 13th, my lord, 13th December.
In 12.
13th December, my lord.
You tell us what you have stated in the report.
My lord, as per Lordship's direction, my lord, page 2 of the order, particularly my lord, paragraph number 2, Lordship has also appreciated the fact that on our submission that regarding the CCTV footage camera, my lord. So, my lord, the operation of this camera, which have already been installed, in our affidavit, we have stated that the camera will be operational from the 24th of this month, my lord. That is the new development we have highlighted in our affidavit, my lord. And number 2, my lord, insofar as para number 3, my lord, Lordship has also directed that when it comes to the walking, my lord, roadside walking constructions and dumping of debris, my lord, widening of roads, those issues also, my lord, we have also taken on board. We have directed, we have requested the local authority, wherever these construction works are happening, not to allow dumping of the debris and the construction materials, my lord. And if any persons are found to be, my lord, violating and creating, my lord, vehicular risk, my lord, for the vehicle accidents, my lord, they have been imposed a penalty, my lord. And in our affidavit, we have also highlighted the numbers of penalty that have been imposed, my lord, the amount which we have collected. Those are in our affidavit, my lord. So far, my lord, we have approximately collected from these violators around 2 crores, my lord. That has been made part of our affidavit, my lord.
You have got a copy of the
We have
report.
received the copy, my lord.
What do you have to say?
My lord, if necessary, we'll reply to it, my lord. We'll need some time to go through the entire report, my lord. And we'll reply accordingly.
All right. List this public interest litigation for further consideration on 2/8 January 2024. The learned counsel for the petitioner seeks time to consider the report filed by the respondents. Paragraph. Learned counsel for the respondents has prima facie apprised us of the contents of the report.
My lord.
Full stop. We shall go into it in detail after the vacation. Paragraph. In the meantime, there is the ensuing Christmas festival and New Year celebrations. Paragraph. The respondents are specially directed to ensure that there is no encroachment of road space, comma, traffic violation by vehicles, comma, littering of the roads by construction materials and other rubbish, and that the roads are kept clear and traffic is regulated so that there is smooth flow of vehicles. Full stop. Furthermore, the respondents will also ensure that no untoward incidents takes place in public places, especially in and around the main arterial roads. Okay. We'll keep it written. Okay. The respondent shall file a supplementary affidavit showing compliance with the above directions of the returnable data.
Obliged. Obliged, Lordship.
Item number 10.
What item number 10? Yes.
My lord, in this matter, the notices are not complete, my lord. Out of 28 respondents, we could serve 23 of them, my lord. And we are filing an affidavit to that effect. 5 are still, we are awaiting the service report, my lord.
All right.
But it grants us some time, my lord.
All right. This application is further adjourned till 6 February to receive the service report.
Item number 11.
All hearing matters adjourned till after the vacation. All right. Hearing matters adjourned till after the vacation.
My Lordship, if I've come from Delhi, My Lordship, I will take only 10 minutes, My Lordship may allow me. Not more than 10 minutes in this. This is on the last leg of the final arguments, My Lordship.
Last leg of the final argument.
All the submissions have been made. Just on the final.
Before whom?
Before this court, my lordship. We're just going to. It's only on the final arguments, my lordship.
This was heard before Chief Justice Vaidyanathan.
Lordship.
Before Justice Vaidyanathan, Chief Justice.
This matter number 11, Lordship, Vikas Soni.
Anyway, you tell us what is the matter about.
My Lordship, this is a case where order had been passed by the learned single judge of this honorable court in our favor, granting to return the gold bangle that was seized from
Yes, yes. In the meantime, there has been adjudication, I'm told.
Yes, my Lordship, they passed an adjudication order.
Huh.
But on the last date of the hearing, the learned counsel was saying that this appeal becomes infructuous. In fact, it is not the case. Otherwise, if it becomes infructuous, then the order of the learned single judge comes in force. Why? Because that order was passed prior to their confiscation, prior to their passing.
What had you challenged in the writ?
I have not challenged. This is their appeal, my Lordship.
No. In the initial writ petition, what had you challenged?
I had challenged that the show cause, according to the show cause notice, should have been given within 6 months of the
110,
seizure.
section
110 too, yes, my Lordship.
So the only area of challenge was not within 6 months. Therefore, the goods are liable to be released.
Returned, yes.
But the adjudication proceedings can continue. Show cause,
May
etc.
continue. They may continue, but I also have legal remedies. I may file an appeal against that order adjudication. The subject matter as of the question in this court is whether the order passed by the learned single judge is correct or not. That is why they have come in an appeal.
All right. Now, those goods are still there. They have not been
Yes.
disposed of by them.
Yes, my Lordship.
Now, the adjudication order perhaps directs confiscation of the goods.
Yes, my lord.
Yes, my Lordship.
Now, it's a subsequent order which has.
But, my Lordship, they should have come with clean hands, because if they earlier, why will they not comply with the order, and why will they not comply with the law? In fact, the law says that the goods have to be returned, so they should have returned it.
You wanted the gold not to be disposed of, but till the adjudication order was passed, for reasons good or bad, the gold will retain. Nothing happened to the goods. They were not
Absolutely, my
disposed
Lordship. I'm
of.
grateful for that order.
All right, but now there is a confiscation order.
Yes, my Lordship.
Confiscation means the property has vested in the government.
My Lordship, that order, that is what I'm saying, I'm submitting, that that order has been passed
Now, what do you
after the learned court,
now what do
honorable
you
court's,
do with that confiscation order?
My Lordship,
You are challenging that
I
confiscation.
will challenge, definitely, my Lordship, because that is on merits. That is on the merits of the case. Because the merits are that the passenger was traveling locally and they had seized the gold, claiming that it has been smuggled. That is a matter of challenge. I mean, we will do it in the due course. But today, as of now, when we are standing here, my Lordship, it's only in the question of whether the gold should have been returned or not. But when it was passed, they themselves were challenging the order, and they themselves were saying it's
We
infructuous.
will give you time
Yes,
to challenge the confiscation order,
yes, my Lordship.
a limited time, within in which time they will hold the goods. And if you obtain an order from that authority for retention of the goods,
Lordship,
they will-
that litigation can continue up till the Supreme Court.
no, but we have no jurisdiction anymore with that limited.
No, my Lordship, this court has the jurisdiction
No,
because there's an order. My Lordship, there's an order of the Delhi High Court wherein this similar thing has happened and it has been upheld by the Honorable Supreme
Your
Court.
cause of action was very short.
Lordship,
Your cause of action was very short. That show cause notice, not within 6 months, release the goods.
yes,
That order was passed.
yes, my Lordship.
Now, subsequent to that, and confiscation order has been passed.
That
So
is
it's
what-
a subsequent
Lordship,
event.
This is what happened in a similar case in 2019 at a divisional bench in Delhi High Court, and it was ordered that this order does not stand because this was passed not prior to the Honorable High Court's order. It was passed after the order.
Maybe, but there was no stay order.
There was no stay, my Lordship, but
The investigation and proceedings were not
Lordship,
made.
when the law says the goods have to be returned, they are supposed to be. My question over here today is, I am standing is, I want the goods to be in my hand because the law says. Subsequently, they may pass an order. I may challenge that order up till the Supreme Court. If they say tomorrow, I will hold the goods with me. I will not dispose it off. When the case attains finality, if I am liable to return the goods, I will return it, Lordship. Or if I will be liable to pay the duty, suspension, penalty, whatever I am willing to. But the law says it has to be returned.
Specific liberty was given by Lordship's, my lord, by order dated 25/11/24, that the adjudication proceedings will continue, my lord. And that has culminated into a final order, my lord. My lord, it is something like what is the purpose, my lord? That is a question I'm asking myself. We return the gold and confiscate it at the same time, my lord, immediately within 5 minutes.
They themselves challenge the appeal and themselves pass an order and say that our appeal is infructuous. It is not. It is bad in law, my lordship. The purpose was for my coming to this honorable court was return of my gold, return of my bangle. That is the question. I came here. I got the order. They appealed and then they smartly played out by passing an order.
We will dispose of this matter on the 28th of January. On that day, you can appear online if you like. You are most welcome physically, and you can appear online also.
Obliged.
But till that time, you hold the goods.
Well, that order is
Highly obliged.
All right.
There are two items, item number 11 and 12. Sorry, 12 and 13. 12 and 13.
dictating the order, I think.
Oh, I'm sorry.
Please take down. We have heard learned counsel for the appellant. List the appeal for further hearing on 2/8 January 2025. Status quo regarding the goods, regarding the seized jewelry is to be maintained by the appellants.
The lordship may kindly keep it for 29th, lordship.
All right, 29th. Yes.
Highly obliged.
Well, there are two items number 12 and 13.
Yes.
Then these are also fixed for hearing, but since it is not possible.
After the vacation, we will hear it.
If your lordship kindly gives us a date on 5th of February.
All right. Yes. Who's for your father?
He is for the appellant. I am for the respondent.
Yes, Mr. Advocate.
Yes, Lordship.
By consent of learned counsel for the parties, list these appeals for hearing on 5th February.
Yes, please.